I'm Michael Hackard with Hackard Law. Here's a question we hear all the time. When someone dies, who gets paid first? Creditors or beneficiaries? It's a fair question and an incredibly important one if you're dealing with a loved one's estate in California. Let's break it down. When a person passes away, they often leave behind more than just property. They leave behind debts, medical bills, mortgages, credit card balances, and those debts don't simply disappear. They become part of the estate administration process. So, who gets paid first? Short answer, creditors. Long answer, it's complicated. California law sets out a very specific hierarchy for how an estate's money gets distributed. This is known as Probate Code Section 111420, and it's designed to protect everyone involved: creditors, beneficiaries, and the person managing the estate. Let's go through the order. First, expenses of administration. These are the costs of actually managing the estate: court filing fees, attorney fees, appraisals, and compensation for the executor or trustee. Second, secured debts, mortgages, car loans, anything backed by collateral. These debts must be handled often by selling or transferring the asset. Third, funeral expenses. Reasonable burial or cremation costs come next. Fourth, expenses of last illness. Medical bills from the decedent's final illness are a high priority. Fifth, family allowance. In some cases, a surviving spouse or minor children may be granted temporary financial support. Sixth, general debts. This includes credit cards, personal loans, utility bills, and other unsecured debt. And finally, seventh, distributions to beneficiaries. Only after everything else is paid do the named heirs or beneficiaries receive their share. This surprises a lot of people. They think being named in a will means an automatic payout. But in reality, the law says debts come first. If there's not enough money in the estate to pay everyone, beneficiaries may receive nothing at all. It's called an insolvent estate. And then when it happens, lower priority debts may go unpaid and beneficiaries are last in line. Now, let's talk about trusts. Many Californians use revocable living trusts to avoid probate. But does that mean creditors are out of luck? Not necessarily. Creditors can still file claims against a trust, especially if the trust holds most of the person's assets. Trustees have a duty to notify creditors, review claims, and pay valid debts before making any distributions. If the trustee ignores this responsibility, they could be personally liable. That brings us to an important point. Timing matters. Creditors only have a short window to file claims, usually 4 months, from the appointment of the estate's personal representative, or 120 days after notice from a trustee. If they miss the deadline, they may lose the right to collect, even on a valid debt. But beneficiaries need to understand no distributions can legally happen until those windows close and all valid debts are paid. Trying to skip ahead, grab assets early, or ignore creditor claims, that's a fast track to court and potentially personal liability. So what should you do if you're a beneficiary wondering why the process is taking so long? Be patient and ask whether all creditor claims have been resolved. A trustee or executor, follow the legal steps carefully. Skipping the order could cost you. A creditor, act fast. If you miss the deadline, your claim could be barred forever. At Hackard Law, we guide families, beneficiaries, and fiduciaries through this exact process every day. Whether you're trying to protect your inheritance or resolve a claim, we're here to help. I'm Michael Hackard. Thanks for watching. If you have questions about creditor claims or estate disputes in California, call us today for a confidential consultation.